Another question for Colin and the panel as well is looking back at the federal case in which Muwekma argues that its right to equal protection under the laws was violated, explain to us how the judge arrived at his eventual decision, and why did the judge agree with the BIA's post hoc rationalizations by the federal dealings rationale to deny Muwekma? That's a complicated question, but
yeah, essentially in that explanation that I described, they referred to. They described the interaction of the three, mostly Lower Lake and Ione, of those tribes interacting with the United States as more voluminous, more frequent than Muwekma. There is with Lower Lake, the BIA. So all three tribes were very similarly situated. They were all identified as eligible for land under the Homeless Indians Appropriations Act. BIA bought land for Lower Lake. They tried to buy land for Ione and failed. They ran into title troubles with the parcels of land they were going to buy for them, so they never bought it. With Muwekma, they identified Muwekma as eligible and retained Muwekma on the list for a number of years, but then at some point, as we know, Mr. Dorrington decided to remove them from, or to no longer consider Muwekma eligible for land. Now, and this was, I'll point out, at that point in time, this was just before the termination policy started. So there were folks in the BIA who were already thinking that the BIA needed to, quote, get out of the Indian business in California. It was California's too big, too many little communities. They were already behind. They had not provided for all of these communities in central and northern California. Better just to stop and not do it. And that actually led to the congressional termination policy. But the folks in the Sacramento agency who were working with Dorrington around that time were pulling back in terms of BIA support for tribal communities with respect to, and so the pattern of federal dealings is essentially the BIA saying, well, the BIA interacted with these other two tribes more, and so that's different. Now, that wasn't a distinction or even a basis for the reaffirmation of Lower Lake or Ione. They merely said that they were previously recognized, not terminated, and for unknown reasons, not served for some period of time. That describes Muwekma. That's exactly Muwekma's circumstance. This distinction between, well, they bought land. The land they bought for Lower Lake. They never bought land for Ione. They bought it for Lower Lake, and then they sold it. They terminated the rancheria. And there were, some. They pointed to a couple of instances of additional interactions between Lower Lake and Ione and the BIA. There was an instance where folks from the Ione community went to the BIA and asked them for assistance, and I think they said no. And one of the questions that they asked them was, well, have your people gone to schools, to BIA schools? Have we served you? And I think the answer to that was no. Well, in Muwekma's case, Muwekma children had gone to BIA schools. And now even since then, in another context, but a very similar context, in order to take land into trust for a tribe after the Carcieri decision, the Supreme Court ruled that a tribe had to be under federal jurisdiction in 1934, and Interior has to have make a determination that they were under federal jurisdiction in 1934 in order for the tribe to be eligible for fee to trust acquisitions, taking land into trust on behalf of the tribe and transferring it to the United States in trust for the tribe. They have to make a determination that the tribe is under federal jurisdiction. Well, now there have been several decisions, including in the last few years, including the Mashpee Wampanoag decision involving a fee to trust transfer, where they relied expressly on attendance of the tribe's children at BIA schools. In the Mashpee decision, that was they had attended Carlisle Indian School, and the reliance on a solicitor's opinion. All of this post the Muwekma decision. They point out that the boarding school policy was a very comprehensive, extensive, important policy of the United States government to assimilate Indian children. and they established these boarding schools for Indian children, and took charge of the children. And they concluded that was the exercise of jurisdiction, not only over the children, but over the tribe. So the Bureau's position in the recognition decision from Muwekma is flatly contrary to the reasoning of these FETA trust decisions and these under federal jurisdiction determinations. That's a problem for the reasoning of their decision.
So does that push Muwekma's federal recognition or being under jurisdiction up to 1947 when their children went to Indian boarding schools, theoretically?
Yeah.
So the gap narrows in terms of them trying to have to prove continuity between point of last recognition and 1965. So now the gap is between 1947 and 1965. It's a very small window.
Except there's an enrollment that occurs in the 50s with the Indian Claims Commission. So then you've got the 50s too. So then every decade there's a substantiation.
They were enrolled in the 60s as well under the California Judgment Act. Yeah, I think the Bureau's decision not to recognize or not to treat enrollment of Muwekma's children, and they've done this in other recognition decisions in California. They take a very firm position that a enrollment in a claim for claims purposes is not recognition of a tribe as an entity. But if you look at the applications, as has been discussed, if you looked at the enrollment applications, they expressly request the applicant to identify their tribal affiliation, and that has to be witnessed by another person, and it's reviewed and either approved or rejected by the BIA examiner. And there were applications rejected. There were people from out of state. There were people they were rejected because of questions about the tribal affiliation response. So I think it would have been absolutely appropriate, and I argue the correct resolution to say that is the BIA not only recognizing the tribe as a tribal entity because it's enrolling its members under the California Judgment Act, but there's associated evidence of the families organizing in order to witness for one another and become eligible under the statute. One talking point I do want to get out there that I prepared. One broken feature of the recognition system that I believe exists is the federal government has a trust responsibility to Indian people of this country, and they have a trust responsibility to the Muwekma people. And as we've learned about the history in California, first there was the mission system. So the Muwekma's ancestors were forced into the missions to work, and essentially as indentured servants. They were at some point and then and they were no longer subject to the mission system at the end of the mission system. The United States government took over the control of California, did nothing in this region for Indian people, and in fact, the treaties were negotiated for this area, and the Senate tucked them away and never ratified them. Nothing was done for tribes in central California, in this part of the state, until the early 20th century. And Muwekma was eligible but not served. And essentially what the BIA is saying with this is, well, we violated our trust responsibility. We didn't serve you. We didn't help you protect, we didn't help provide for your land. We didn't provide a home for you or education, well, except for the few children. But you have to show that you survived, and as a community, as a polity, and you have to document it. And you have to maintain those documents for 100 years and present that to us. And, if there was if you ever had the documents, but they were lost or burnt down in a fire, which happens to a lot of, local and federal and state government offices, too bad. If you can't document it, then from our standpoint, it doesn't exist. I think that's a breach of the federal trust responsibility, and really something that the Department of Interior and Congress should make right.